today, Your Honor. I am the beneficiary.
And then who are you?
I am the beneficiary of the trust.
Okay, well, Mr. Beneficiary, take you and your trust back to jail.
I have some questions for the clerk, Your Honor.
No.
Can I speak to the clerk before we go any further? Trust that we are now administrating.
Sir, I asked the questions here. You give me yes or no answers.
You're asking for my permission
I
to
ask the questions, you give the answers. Is that clear?
It's very clear.
Okay, listen.
Yes.
Are you also known by the name of Kevin Pollard amongst other names? Yes or no?
Mr. Beneficiary, Mr. Beneficiary, you should not come over to the court. Thank you very much.
You are under oath and you are on record. And I'm asking you,
Beneficiary, I have not sworn you under oath. I am under oath, so I am doing all this. I'm going to enter plea of not guilty. I already given the court dates. That the clerk has declined to talk to the gentleman in front of the screen.
That is not fair.
Thank you.
That is not fair. You cannot do this. Under oath and on record, you cannot do this. I have rights, and you violated them, and you was not my judge.
Okay, you can go. Go ahead and do whatever.
Do you understand?
No, I do not understand, and I do not stand under the charges. I am one of the solvent living people.
Okay, sir, I'm not asking you if you agree with me. I am asking if you understand the words that I just said to you.
Beneficiary.
Oh, he done this before.
What's his name?
The beneficiary.
Yeah. First name, Mr. Beneficiary.
Are you stating that the trust that we are administrating is the Kevin Pollard Trust? If so,
I'm asking what your name is.
my name is the beneficiary of the trust.
Of whose trust?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor?
Okay, I'm gonna recall him. Bring up somebody else. Put him aside. We'll call him at the end.
Thank you, Judge.
All right, who's next? DDC.
Do you want Pollard back?
Pollard?
That's the last one. Homicide.
Does he have his mind right?
I don't know him.
All right, let's give it a try. Sir, is your name the beneficiary Kevin Teron Anthony Pollard? Yes or no?
I'm the beneficiary of the trust, Your Honor. Are you stating that the trust that we are now administrating is the Kevin Pollard Trust?
Are you Kevin Pollard? I'm asking you.
Is the trust that we are now administrating?
Sir, I asked the questions here. You give me yes or no answers.
You're asking for my permission to
ask the questions. You give the answers. Is that clear?
It's very clear.
Okay, listen.
Yes.
Are you also known by the name of Kevin Pollard amongst other names? Yes or no?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor? If so, Kevin Pollard is in fact present today. It is you that is Kevin Pollard, Your Honor. It is you.
Really?
Yes, Your Honor. It is you. That is
that
Kevin Pollard. Yes, Your Honor. You are Kevin Pollard today, Your Honor. I am the beneficiary.
And then who are you?
I am the beneficiary of the trust.
Okay, well, Mr. Beneficiary, take you and your trust back to jail.
I have some questions for the clerk, Your Honor.
No.
Can I speak to the clerk before we go any further?
You know what? I'm gonna put you in timeout. Get your mind right. Mr. Pollard?
Yes, sir. Can I have the clerk present? Please, Your Honor.
Don't get banned.
Please have the clerk present in a Zoom meeting.
You know what? If you answer my questions, I'll consider it.
Okay. What's the question?
What's your name?
The beneficiary.
All right, Mr. Beneficiary, put you back in timeout.
Your Honor.
I say outside. Give me one moment, Mr. Ragnar. I got to walk in. I'm going to take care of, and then I'll address your concerns.
Thank you.
All right, beneficiary. I'm going to give you another chance in front of another magistrate.
That's no problem. Can I have the clerk present, please?
Hey, sir, I'm Magistrate Chartea. DDC.
Excuse me? Yeah.
I'm talking to the DDC officer.
Yes.
DDC?
Yes, ma'am.
Okay. The gentleman that is in front of the screen, in front of camera 1, what name do you have him listed as?
Kevin Pollard.
Do you have a middle name?
No, ma'am.
Okay, so you have a Kevin Pollard. Okay, and sir, you're identified as Kevin Pollard, but you're considering yourself the beneficiary. Is that correct, sir?
Are we on the record?
We are. Everything is on the record.
Okay. Are you stating that the trust that we are now administrating is the Kevin Pollard trust, ma'am?
I'm not administrating any trust because there is no trust in front of me. But what I'm asking you is, you call yourself the beneficiary. Is that correct?
Yes, Your Honor.
Okay, no problem. I have case number is 240-5538101. People of the state of Michigan versus Kevin Theron Anthony Pollard, who is listed by DDC as Kevin Pollard. However, the gentleman has identified himself as the beneficiary.
You representing as Kevin Pollard today, Your Honor.
Mr. Pollard,
I'm not.
Mr. Pollard, as your counsel, I am going to advise that you stop speaking and allow the judge to speak.
Yes, ma'am.
Counsel Kirkland.
Good afternoon, Your Honor. Shava Kirkland on behalf of Mr. Pollard, who has been advised of his rights, wishes to stand mute and waive the formal reading.
Thank you. I'm going to enter a plea of not guilty. Court dates are February 2nd, 2024. It is a probable cause conference, followed by preliminary examination, February 8th, 1:30 p.m. Both matters are in front of Judge King. The probable cause conference, it is at 8:30 in the morning. Mr. Beneficiary, you should not come over to the court. I thank you very much.
You are under oath and you are on record. And I'm asking you,
beneficiary, I have not sworn you under oath. I am under oath, so I am doing.
The sovereign citizen script feels empowering because it reframes the defendant from someone facing charges into someone outside the system entirely. But the court does not recognize that identity shift. Every refusal to answer basic questions removes credibility and increases the judge's willingness to treat the situation as deliberate obstruction.
I'm going to enter a plea of not guilty. I already given the court dates while this case is pending, sir. Okay, there should be no contact with the individual.
You are not allowed to state what the judgment is. That is my job.
Mr. Pollard, I do want to let you know that the person.
Okay.
I have a question for the clerk.
Okay.
I have a question for the clerk. I have a question for the clerk.
You will give an opportunity, sir. You will give an opportunity. Let me finish. While this case is pending, there's no contact with no person contact, no contact to third parties, no phone calls, no emails, no text messaging. The people, go ahead, Esteban.
Yeah, the people are asking for $250,000 cash bond, no cash, no surety. If he's able to ever post bond, we'd like GPS tether with home arrest. The defendant, Your Honor, has a continuing situation where he entices young girls on the internet from Arizona in this particular case, and previously on 10/23/2023 in another case where he enticed people. He's been arrested 3 different times for criminal sexual conduct. The first case, he was found not guilty back on 5/15/2015. The 10/21/2023 case, where he was criminal sexual conduct first degree and also contributing alcohol to a minor, 2 counts of that, was at the exam dismissed without prejudice. And my belief in all that is because these victims all live out of state. In our particular case we have here today, Your Honor, the victim is from Arizona. She came here after having a relationship, not the victim, but one of the witnesses came here after having a 3-year relationship with this defendant on the internet. When she turned 18, she came to visit. And also Mr. Pollard introduced her to another girl who is also from Arizona. The other girl brought her niece or her, I forgot who, the relationship, but her 7-year-old niece with her to visit Mr. Pollard. And what happened then, because the person was tired from traveling, she fell asleep in the living room. When she woke up, she went into the bedroom, and there was Mr. Pollard with the 7-year-old girl. He then said, "What are you doing?" And he says, "Well, we're playing video games." So the woman, the adult in the room, she falls asleep again. And then she is awakened by the 7-year-old girl and asked to leave. The 7-year-old girl then tells her mother that Mr. Pollard touched her, and she asked him to stop, and that's when they left. Now, what happened is, though, when he was asked that question, if he did do that, he goes, "Well, I carried her into the bedroom. My hand may have rubbed up against," he says, okay? He said, accidentally is what he's trying to tell us what happened. The situation is she's told, the 7-year-old child has told TED Talk that he did this. He's told Protective Services that he did this. And as far as I'm concerned, Judge, he fits the category of a predator because he did the same thing in the 10/23/2023 case of enticing young people from other parts of the country, perhaps, I don't know where exactly, to come and see him on the internet. So we're asking for $250,000 cash bond, no surety, and GPS tether if he's ever be able to post bond, Your Honor. Thank you.
Okay. One question, Counsel Ragnan.
Yes.
Does he have any pending cases?
Not that I know of, Your Honor. The 10/21/2023 case has been dismissed without prejudice at the exam, and I couldn't find out if the witness was out of town or what the problem was. But
okay.
Thank you.
Thank you. Okay. Counsel Kirkland, go ahead, Esteban, please.
Thank you, Your Honor. I'd ask this court, understanding the seriousness of these charges, for a 10% bond if this court is not inclined to do a high personal bond. So one, I know the bulk of Brother Counsel's argument was this dismissed case from last year. I'd ask that this court sentence him based on these allegations and the facts and details surrounding this case. This is a 2020 case. And the woman that he met was 20 years old, or that came to see him was a 20-year-old woman, was not an underage woman. And the allegation is that she brought her, I believe, goddaughter to the home. Now, there are different variations because a couple different stories are told as to what occurred there. But Mr. Pollard has maintained that he did not actually assault the little girl. I'm not sure why this case wasn't charged until 2024, but it is a 4-year-old case. My understanding is that he, I don't believe he's had any convictions since then. He is a lifelong resident, has a child, so he has strong ties to the community. He also owns a lawn service here. At this point, there's no amount of bond that he can't afford to pay, so even a 10% bond would be unaffordable for him. But given the age of this case and his lack of issues since this, I'd ask this court consider a high personal bond, if not that, a 10% bond.
Thank you. I've heard the representations from both sides in this particular matter in reference to the beneficiary who is listed by the court or by DDC as Kevin Pollard, is that in this particular matter, even though this is from 2020, okay, there was a forensic interview, Kids Talk, with the victim, and she disclosed that she was touched by the defendant and that he rubbed final with his hand. This court is not considering the other cases that were dismissed. They were dismissed without prejudice, okay? This court is only going with this matter. In reference to this gentleman, the defendant, bond is going to be $250,000 cash. There's going to be a GPS tether, home arrest. Further, okay, it's going to be unaffordable. So today is Friday. He's going to get another court date. Today is the 26th, January 29th, 2024, 9 o'clock in front of Judge McConicle, who's going to be looking at the bond amount and bond conditions. Also, there is one other thing. This court looks at clear and convincing evidence standard, okay, based on the representation, based on the reading. This court is convinced that Mr. Pollard, okay, I'm sorry, the beneficiary, okay, that he is a creditor in this particular matter. That's why we're putting at $250,000 cash, GPS tether, house arrest. He does have the, again, the unaffordable bond redetermination for this Monday, January 29, 2024, 9 o'clock in front of Judge McConicle. Also, there's another bond condition. He's not to be around any minor children. That concludes the arraignment of the beneficiary, also known as Kevin Pollard. Madam Clerk.
Pretrial, Your
Do you
Honor.
wish to talk to the gentleman that's in front of the screen?
Judge.
Okay. Just so for the record, is that the clerk has declined to talk to the gentleman in front of the screen.
No, that is not fair.
Thank you.
That is not fair. You cannot do this. Under oath and on record, you cannot do this. I have rights, and you violated them, and you was not my judge.
Okay, you can go. Go ahead and do whatever.
You cannot do that.
Okay.
As the beneficiary, I asked the
I'm sorry?
Can we have those dates again? We couldn't hear them.
Over the dates?
February 2nd, February 8th.
February 2nd, February 8th. Bond
The clerk
redetermination
administrator
Monday.
of this QV trust account that she are.
Huh? What you say?
Thank you.
State of Michigan versus Eric Martin, case number 23-00425.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Eric Martin.
You here as standby counsel?
I'm here as standby counsel.
Do you know where Mr. Martin is?
I am shocked. Mr. Martin has almost called me every night. I did attempt to call him earlier. It sounds like his phone must be off because it said not accepting calls at this time. So I guess on his behalf, I will be asking for an adjournment because like I said, I talk to Mr. Martin every day.
Ms. McDuffie?
Well, Your Honor, I guess I will inquire of standby counsel, recognizing that he does not want any attorneys in this case. We adjourned, I think it was just about 2 months ago, because Mr. Martin wasn't able to review the video in this matter, and he was supposed to be hooking up with Ms. White to do that. So I'll ask if they were able to do so. And where that stands, I'm not requesting a bench warrant because he makes sure that he comes every time and talks quite a bit. So I'm sure he wanted to say more today. So this will be his first failure to appear, but I just want to know where we are with the case.
We watched the videos, yes.
Good, excellent, okay. So I don't mind a show cause.
Show cause and pretrial will be scheduled for March 14th, 2022 at 9 a.m.
Good morning, Mr. Martin. Can you hear me? You're muted. Now calling case number 23S00425. This is the state of Michigan versus Eric Martin. Can I have appearances for the record, please?
Stephanie Cannon with the Washtenaw Public Defender's Office on behalf of Mr. Martin, who is present, Your Honor.
Thank you. Mr. Martin, can you please state your name for the record?
Capital E, lowercase R-I-C, capital M, lowercase A-R-T-I-N.
Okay, thank you, sir. Today is the date and time set for an arraignment in this matter. What I am seeing is that you failed to appear for a court date on February 1st and that you failed to appear for another court date on March 14th. Therefore, a bench warrant did issue for your arrest. Do you understand?
No, I do not understand, and I do not stand under the charges. I am one of the sovereign living people.
Okay, sir, I'm not asking you if you agree with me. I am asking if you understand the words that I just said to you.
Well, I do not understand. I might comprehend that I do not understand and that I do not stand under the charges. And I am not a defendant. I am a living human sovereign. I'm not the legal fiction corporate entity, all capital letter name.
Attorney
I do not accept an attorney.
Thank you, Your Honor. At this time, he would stay on mute and ask for a PR bond.
Objection. You're not speaking for me. You're not my attorney. If you think you're my attorney.
Thank you for the attempt, Attorney Cannon. You can turn your camera off.
Thank you, Your Honor.
Okay, Mr. Martin. At this time, I am seeing that your license has been revoked. You have failed to appear for court dates in front of Judge Washington. You were to have a sentencing hearing and a pre-trial date in front of her, so that is what I am going to set you for now.
That wasn't finished. Cut me off.
Okay.
I had more to say.
Sir, I am setting you for another. Yes, I am, because what I am doing today is arraigning you, and I am setting you for another court date in front of Judge Washington. That court date will be April 11th, 2024. That will be at 9 a.m. That will be for your pretrial and potentially your sentencing.
I can't remember all this at once. The date is when again?
April.
Yep.
11th.
Yep.
9 a.m.
All right.
That is 9 in the morning.
Okay, now. Okay, is that it for that? Okay, now. Let me ask, so does she call herself? Is this a separate charge?
I'm not entirely sure what you're asking. So what happened here was that a bench warrant was issued for your failure to appear. At this time, to guarantee your appearance at the court date on April 11th at 9 a.m., that warrant will continue.
Okay, that wasn't intentional, so that's why it's baseless. It's baseless, and it shouldn't have been the warrant issue because.
Okay, sir, you've got your next court date. That's April 11th at 9 a.m. The bench warrant is continued. This hearing is concluded, and you are free to sign out of Zoom.
So I have more to say. I'm not done saying what I have to say. Pursuant to my First Amendment right, I have more to say here. That is,
All right, the court will call the case of the State of Michigan versus Eric Martin, case number 23S00425.
Rachel McDuffie for the people.
Mr. Eric Martin, please unmute your device, and state your name.
Can you hear me?
I can now, sir.
Capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N family. A living sovereign, one of the people.
Assistant Public Defender Don Lebo as standby counsel.
Thank you. We're here for a pretrial today, and a bench warrant is still outstanding for Mr. Martin.
That's correct, Your Honor. As it relates to the pretrial, I believe the last time that we saw Mr. Martin, it was on December 7th, and he had some difficulty viewing the video that we had sent via flash drive. I encouraged him to get with his standby counsel, who at that time was APD Sandra White. He did not appear at that next hearing, but she did confirm that they had spoken almost every day and that they had reviewed the video. So my understanding is that Mr. Martin has been able to view the complete discovery, including all of the media. I know that we were headed to a jury trial, so I will leave it to Mr. Martin to confirm that so we can get going with selection.
Mr. Martin?
Yeah, I looked at the video. And I found I looked at the video, and I also found some demands to dismiss, some self-incrimination based on the video, along with some others that have not been decided on. which should be decided on before any trial schedule or anything else.
Mr. Martin, I've decided on all the motions that you brought before me. And the way this works is if I make a motion ruling, then the party making that motion has to prepare the order. So when you complain about no orders being prepared, that's your not preparing them, sir.
What do you mean not prepared?
I think my words were very clear.
I understand what you're saying. You're saying because I didn't style it as a motion or something? What are you saying?
I'm saying that I already ruled on them. So when I rule on them, it's up to the party to prepare them. That's you.
I did prepare them. Specifically, my demand to dismiss.
Sir, you did not prepare my ruling order, which was that they are denied.
What do you mean they're denied, but you didn't rule on it? How does that happen?
Do you have anything else? Yes, Ms. McDuffie.
I'm sorry, Your Honor. I did just want to clarify one point because Mr. Martin, I think, mentioned that he had he wanted to move to dismiss based on incriminating statements after he had reviewed the video. So I don't know if there's a sort of Miranda issue he's raising or not, but I would just, I guess for the record, remind Mr. Martin that when he appeared for the hearing on the 5 documents that he filed, demands, motions, whatever you want to call those, Mr. Martin, during that hearing, rattled off the fact that he did not have a valid license, his vehicle wasn't registered, and he didn't have insurance and didn't feel like he needed to do any of those things. So if there are any incriminating statements that would relate to the counts in this case, he has made them multiple times, including on the record in this court at his own hearing. So if any statements were suppressed from that media, they would still come in from statements he's made in court.
Well, I object to that. The third one is self-incriminating. As I pointed out and stated in my demand to dismiss, as the U.S. Supreme Court said, license ain't necessary. We're not using the streets for profit, which the cops have no evidence.
Mr. Martin, you're gonna need to speak up if you want to have a transcript of this because it's not. Can you bring the microphone closer to you, Mr. Martin?
Yeah, let me see.
I'm sorry.
Kind of a little closer now. How's that?
Is that any better?
How's that?
How's that? Yeah, please keep talking in the same volume that you're using right now so we can hear it.
Well, I object to what she just said about I made some self-incriminating statements. That's not true because as I pointed out in my demands to dismiss, the law is in my favor, the higher supreme law, such as the statute, which is supreme law of the land under Article 6 of the U.S. Constitution. Federal statutes override state statutes, along with the Packer versus Benton case I cited and sent a quote from the law book on that clearly said from the U.S. Supreme Court that the people have a right to use the roads, not a privileged right. And as long as you're not using the streets for profit, which I wasn't doing, and there was no evidence, and the cops have no evidence of that. So I was exercising my right to travel, didn't need a license, insurance, registration, none of that. So nothing self-incriminating about what I say. There's no legit case here. And which is why I beat a case on the same exact issue in Southgate. Same exact issue. Prosecutor moved to dismiss it because they know they had to win the case. The higher law is in my favor. The state law is unconstitutional. That's assuming everyone's driving a motor vehicle when they're not. And I'm working to change that state law, and I'm going to. I already got a federal lawsuit filed on it in the Detroit courthouse on Lafayette Boulevard. Right now, I got to fight one about filing fees. But when I overcome that, they'll be deciding on the merits, and I will be winning on that issue, and the state law will be changed. It's going to stop making the presumption, the state statute law, that everyone's driving a motor vehicle, even when it's not for profit. That's the problem with the state law. It's unconstitutional. Cops are blindly following that, acting as if that, and then the so-called courts are acting on that presumption. No, everyone's driving a motor vehicle. They need a license, insurance. So no, they don't. They're not doing it for profit. They're exercising the right to travel.
So, Your Honor, since I'm sorry, Mr. Martin. Since Mr. Martin has again made those same statements that I referred to earlier, and this prosecutor will not be dismissing anything in this case, we will be proceeding to trial if he doesn't want to plead to it. Let me ask the court if I could Are we ready to set this? I understand he has a desire to file an endless amount of lawsuits and grievances and motions, but the court has indicated we are past that point. Are we ready to set this case for jury selection or no?
Yes, we are.
Thank you.
All right, any motion that was just made, whatever he's entitling that, is denied.
Heidi, so you deny some, you don't even know what it is. But anyways, you still have, there's still demands to dismiss that haven't been ruled on as a matter of law, which what a lot of them are, such as the state as a party. I filed a demand to dismiss because the state is the party here. Plaintiff. The state in this court, so-called court, has no jurisdiction, as I indicated in my demand under the U.S. Constitution. Only the
Sir, I'm not hearing those motions again. On October 26th, I made a ruling on all of those motions, and you have not prepared the order to that effect. We're done with those motions.
It's in order.
Is that the May jury selection, Your Honor? Or
No, it's not. We're gonna do a July 25th July 25th final settlement conference.
Okay.
August 9th.
July 25th, 2024.
Hold on, let me write this down here.
Hold on 1 second. 1 second, please.
And I'm also going to make a demand right now for compensation also for this making me proceed against my will under threat and duress to these so-called court proceedings in violation of my 13th Amendment right against slavery. All these court proceedings are against my right against slavery. So I'm entitled to compensation for all the court proceedings that I had to make in this case. Otherwise, I would have possibly been arrested. So it was only under threat and duress. It wasn't by consent willingly.
Mr. Martin knows that the jury selection is in person, correct?
I haven't finished telling him all of that yet. I'm getting the dates. I'm going to tell him in just 1 second. All right. The final settlement conference in this case is going to be on July 25th, 2024 at 11 a.m. And that is on Zoom. The August 9th jury selection is in person, and that's at 8:30 a.m. on August 9th.
Hold on, July 25th, 24, right? 8 p.m. a.m. you said, right?
It's at 11 a.m., sir.
You know, I want to be understood. I'm not willingly giving up my right to be one of the sovereign people and by this jury, but you know.
Jury selection is August 9th, 2024 at 8:30 a.m.
You said 24th?
It's at 8:30 a.m. I meant to say 8:30 a.m.
You said the 24th now, or you say the 25th?
August 9th, 2024 at 8:30 a.m. is the jury selection, sir.
I thought you just said 7/25/24.
That is the final settlement conference. That is on Zoom.
Hold on, I got one thing at a time. Okay, now let's do the what's the other date now? August. What else?
August 9th.
Okay.
At 8:30.
8:30, and what's that considered? What's that called there?
Jury selection, sir.
Now, which is in person here now? The 7/25/24, is that something I have to be there in person for? I'm being
for the fourth time, Mr. Martin. Please listen. The first event, which is in July, is on Zoom. The last event is in person.
We got it. So you're saying a whole bunch of wonders, you know.
All right, we're done today. Have a good day, Mr. Martin. Bye-bye. The court will call the case of the state of Michigan versus Maurice Jordan, case number 22S00351.
APA Rachel McDuffie for the people.
Across both hearings, the pattern is the same. Identity arguments colliding with procedural law. Sovereign citizen ideology often relies on a central idea, that a person can separate themselves from the legal identity the court is addressing. Words like beneficiary, living man, corporate entity, or sovereign people are used as if changing the label changes the court's authority. But criminal courts don't operate on philosophical identity claims. They operate on jurisdiction, charges, and procedure. In the first case, the defendant tries to avoid the court's authority by claiming to be only a beneficiary of the trust. From the court's perspective, that isn't a legal argument. It's simply a refusal to confirm identity. And when a defendant refuses basic identification, the court moves forward using the records it already has. The consequence isn't debate, it's loss of control over the process. In the second case, the strategy shifts to another familiar sovereign citizen claim, the right to travel. The argument attempts to transform driving laws into optional privileges by arguing they only apply to commercial activity, but courts have rejected that theory for decades. The real risk is that every time the defendant explains the theory on record, he reinforces the prosecution's case rather than weakening it. That's the deeper pattern in sovereign citizen cases. The arguments are designed to escape the legal system, but the courtroom runs on procedure, not ideology. And when someone keeps arguing the theory instead of responding to the charges, the court doesn't slow down to debate it. It simply keeps the case moving forward.